This is Barry Zalma on insurance. I am an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, producer of these videos, and an author. Today I'd like to speak about different ways other than negligence an insured can be found liable for damage to third parties. First, let's talk about the concept of strict product liability. Strict product liability is a legal rule that says a seller, distributor, or manufacturer of a defective product is liable to a person injured by that product, regardless of whether the defendant did anything possible to make sure that the defect never happened. Strict product liability is a manufacturer or seller's tort liability for any damages or injuries suffered by a buyer, user, or bystander as a result of a defective product. Product's liability can be based on a theory of negligence, strict liability, or a breach of warranty. This rule applies even if the seller exercises all possible care in the preparation and sale of the product, and the user or consumer has not bought the product from or entered into any contractual relation with the seller. Strict product liability, like negligence, still must be proved. Strict product liability is different from negligence, however, because the duty element is assumed. The plaintiff must only prove he or she was injured by the product, that the injury occurred because the product was defective, and that the defect existed when the product left the hands of the defendant, manufacturer, or seller. A plaintiff alleging a claim for strict product liability must prove the following 5 elements. 1. That the product was in defective condition when it left the possession or control of the seller. 2. That it was unreasonably dangerous to the user or consumer. 3. That the defect was a cause, that is, a substantial factor of the plaintiff's injuries or damages. 4. That the seller engaged in the business of selling such product, or put negatively, that this is not an isolated or infrequent transaction not related to the principal business of the seller. And 5. That the product was one which the seller expected to and did reach the user or consumer without substantial change in the condition it was when he sold it. The insurance adjuster should have an independent laboratory when faced with a claim of strict product liability, take possession of the product and have it tested. The adjuster's efforts should be directed to determine if the product was modified, where it was purchased, who purchased it, what use the product was put to by the consumer, its repair history, who used it, if the product had harmful components such as foreign objects in a container of food or dangerous packing, whether there was inadequate warning, for example, if the seller, with reason to anticipate danger from a particular use, failed to give adequate warning on the container, or it had allergy-producing ingredients like nuts, eggs, or milk. The manufacturer of an article is liable for injuries proximately or legally caused by a defect in design or manufacture of the article that existed when the article left possession of the defendants, provided that the injury resulted from a use of the article that was reasonably foreseeable by the defendants. The following products, among many others, have been determined to be defective in manufacture or design: asbestos, computer software, forklift trucks, industrial presses, cranes and lifting apparati, insecticides, chemical drain cleaners, glue and other adhesive products, fertilizers, insecticides, fungicides, weed killers, perfumes, flammable clothing, protective clothing, polio vaccine, diethylcybestrol or DES, contraceptives, and automobiles. In order for the product to be found defective, the plaintiff must demonstrate that the product failed to perform as safely as an ordinary consumer would expect when it was used in an intended or reasonably foreseeable manner. Evidence to establish the defect can be as simple as the testimony of the person who used the product, or as complex as calling expert witnesses, the designer, and the people who assembled the device on the production line as witnesses. For example, in Nevada, when bringing a strict product liability failure to warn case, the plaintiff carries the burden of proving, in part, that the inadequate warning caused his injuries. This case was Rivera versus Philip Morris, a 2009 decision of the Nevada Supreme Court. In strict product liability cases, the plaintiff carries both the burden of production and the burden of persuasion. To successfully prove a failure to warn case, a plaintiff must produce evidence demonstrating the same elements as in other strict product liability cases. A product may be found unreasonably dangerous and defective if the manufacturer failed to provide an adequate warning. Further, the burden of proving causation can be satisfied in failure to warn cases by demonstrating that a different warning would have altered the way the plaintiff used the product or would have prompted plaintiff to take precautions to avoid the injury. In a tort action, the burden of proof is always imposed on the plaintiff. He or she must prove, by a preponderance of the evidence, all the elements of the tort. Once the plaintiff makes a prima facie case, showing that the injury was proximately caused by the product's design, the burden should appropriately shift to the defendant to prove, in light of the relevant factors, that the product is not defective. If the manufacturer shows that it took reasonable precautions to design a safe product or otherwise acted as a reasonably prudent manufacturer would, the trier of fact may conclude that it was not negligent. However, strict liability would be found if the product was defective and the defect caused the injury. In addition to strict product liability, there is the concept of absolute liability, where there is a liability imposed on a owner for dangerous animals and the injuries caused by them. A person who possesses or harbors a dangerous animal, whether wild or domestic, is absolutely liable for injuries inflicted by it, where he knows or should know of its dangerous propensities. In the case of wild animals, scienter, evil intent, is presumed. In the case of domestic animals, the type an adjuster will normally see, it is necessary to establish scienter. Knowledge of the dangerous propensities must be proved by the plaintiff to establish liability. In 1931, California Civil Code Section 3342, the dog bite statute, was enacted, and it held that the owner of any dog is liable for the damages suffered by any person who is bitten by the dog while in a public place or lawfully in a private place, including the property of the owners of the dog, regardless of the former viciousness of the dog or the owner's knowledge of such viciousness. Some people go beyond customary household pets and keep chimpanzees, ferrets, anaconda snakes, alligators, tigers, and lions as pets. These are exclusively wild animals, and the owner will be held liable for any injuries caused by the wild animal. I have personally found cases where monkeys, chimpanzees, and even carnivorous fish in the hands of people who were insured, who took the chance of or actually injured their neighbors and friends because of the keeping of these dangerous animals. Liability of the owner or keeper for injuries from animals are governed by two general rules. One for an animal classified as a wild and savage beast, and a different rule for a domestic animal. A horse is included in that latter classification. The owner or keeper of a domestic animal is liable if the animal is vicious or possessed of a tendency to injure persons, and the owner has either actual or constructive notice of those inclinations. California civil jury instructions provide with regard to wild animals, quote, people who own wild animals are responsible for the harm that these animals cause to others, no matter how carefully they guard or restrain their animals. To establish his or her claim, the plaintiff must prove all of the following. 1, that the defendant owned a vicious animal. 2, that the plaintiff was harmed. And 3, that the defendant's vicious animal was a substantial factor in causing the plaintiff's harm. One who harbors a wild animal, which by its very nature is vicious and unpredictable, does so at his peril, and liability for injuries inflicted by such an animal is absolute. Under the rule of absolute liability, even though a person is licensed to keep and exhibit a wild animal, he assumes the obligation of an insurer to the public, generally, and as such keeps it at his peril. Animals giving rise to absolute liability by their owners include such things as lions, tigers, bears, wolves, elephants, and the like. Article 2321 of the Louisiana Civil Code simply states that the owner of an animal is answerable for the damage he has caused, close quote. The Louisiana Supreme Court interpreted this article in conjunction with other tort liability articles of the Civil Code by distinguishing between domestic animals and wild animals. That court has stated unequivocally that absolute liability applies to keepers of wild animals, while a lesser standard of negligence or strict liability applies to those responsible for domestic animals. Absolute liability is liability without fault. The keeper of a wild animal is absolutely liable for any harm caused by the wild animal, whether that animal is a lion, tiger, or bear, or even an aquarium full of piranha fish. The proof of liability for injury from a wild animal is fairly easy and may be considered a variation on strict liability. In addition to wild animals, when a person or entity conducts an ultra-hazardous activity, that person or entity can be found liable even if that activity is conducted without fault. Certain activities create a serious risk of danger that courts find it justifiable to place liability for the loss on the person engaging in the activity. And to prove that an activity is ultra-hazardous, the plaintiff must establish that the activity is unusual and abnormal in the community, the danger which it threatens to others is unduly great, and the danger will be great even though the enterprise is conducted with every possible precaution, and the injuries or harm is within the scope of the abnormal risk. A defendant is only exempt from liability if the defendant fits within the public duty exemption and is legally required to transport an ultra-hazardous goods such as electricity, atomic fuel, and causes injury to someone during transport. This video was adapted from my book, Zalma on Insurance Claims, Part 105, Second Edition, which is available as a Kindle book or a paperback from Amazon.com. If you found this video to be useful or of interest to you, please refer it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog, where you will find more than 3,500 posts dealing with insurance and insurance claims matters, and more than 100 videos dealing with insurance claims and insurance law matters. Thank you for your attention.